Everyone. Today we are going to discuss a Hindu undivided family, or as it is more commonly known as an HUF. Well, HUF has been provided for legally under the Indian Constitution in Hindu law, and more or less its purposes that it serves today are for taxation purposes. However, the rationale for its formation is the commonness of property, estate, and ancestral belongings, and their common possession, enjoyment, and ownership. So, the belongings from one common ancestor, their common sharing and enjoyment and common possession was the reason an HUF was created. So, a point that needs to be remembered is it is between a family, that is, it has to have a common ancestor. Now, who can form an HUF? An HUF can be formed not only by Hindus as per the Hindu law, but also by Sikhs and Jains. So, okay, another fun fact about an HUF, it is also called co-parsonary. Co-parsonary. Now, let us understand what an HUF is. It is basically a family that consists of a common ancestor and his male or female descendants up to the third generation next to him. Points that need to be considered in this area are a common ancestor, male or female descendants, and up to third generation next to him. Now, third generation is you yourself are the first generation. Your kids will be the second generation, and their kids will be the third generation. So, एक परिवार का बुजुर्ग, उसकी संतानें और उसकी संतानों की संतानें. That is the max extent of an HUF. So, now we come to a little more obscure part of an HUF. There are two schools of Hindu law as per the HUF, and they are 1. Dayabhag and 2. Mitakshar. Now, Dayabhag is applicable only in the state of West Bengal. As per this law, the father, that is the common ancestor, is the absolute owner of all belongings and property. On the contrary, in Mitakshar, which is applicable in the rest of India, all the male members become equal right holders of the family property right from their birth. So, Mitakshar is applicable in the rest of India, and it applies to all the male members of the family who become equal right holders right from their birth. Now, Hindu Succession Act was amended in 2005, and the amendment was made in Mitakshar law. As per this amendment, all sons and daughters become co-parsoners, that is, own the right to family and property from their birth and adoption. Birth or adoption. That is, in an HUF, it is governed by one head member. We would have discussed it later, but now I think we should discuss it right away. The one head member is called Karta, and all the other members in the family are called co-parsoners. So, while in Dayabhag, which is applicable in West Bengal, the role is only held with Karta, and the co-parsoners have no rights or authority. In Mitakshar law, the sons or the daughters, right from their birth or adoption, become co-parsoners. That is, have the right to family property. And from this arrives another important ruling, which is a Supreme Court ruling, that an all-female member cannot form an HUF. At least one male member must exist for the legal formation of an HUF. So, like we talked of Karta. Karta is the lead male member, eldest male member of the family. So, if he dies or becomes insane or personally insolvent, because personal insolvency amounts to the legal death of the person, so then the next elder male co-partner in the family will take place of Karta. Well, the importance of Karta is not only as the head of the family. Legally, he is empowered to handle all the affairs, to the rights of all the property, and its affairs, the business. He is legally empowered to handle it. So, the points to remember are कर्ता जो होता है eldest male होता है. If something happens to him, that is, he dies, becomes insane, or personally insolvent, the next eldest male co-partner becomes Karta. And he is entrusted and empowered by law to handle all the affairs of the HUF business and property. So, Karta's liability is unlimited. He can do anything. As in, his liability is unlimited means if the family is under debt, he is going to pay off till everything he owns. He is also entitled to open accounts on behalf of HUF. So a Karta can come to a bank and say that he wants to open an account on behalf of an HUF. He can raise loans, make repayments of those loans, settle those loans in court, compromise on those loans, and agree to arbitration on any legal matters pertaining to the HUF. He can allow creation of charge on the property, यानी कि वो अपनी property को गिरवी भी रख सकता है. Can appoint an agent. Agents are generally appointed in cases of wills, and can delegate legally powers to the co-partners or people outside the HUF to handle the affairs of the family, property, or business. Now, what a Karta cannot do? A Karta cannot enter into a partnership in his capacity as the Karta of an HUF. He cannot enter into a partnership with anyone. He cannot revive a time-barred debt. So, another point to know is that since an HUF is not governed by the Indian Partnership Act, the relationship between Karta and co-partners is not that of a partnership. The liability of co-partners is limited only to the extent of their claim on the HUF property and not on their personal belongings. So, if the Karta who is running a business and the business goes down, the only thing at stake is the complete HUF family and property, family property and business, and the complete belongings of Karta. Like we discussed, Karta's liability is unlimited. But the rest of the family members, that is the co-partners, their liability is not unlimited. That is, their personal belongings will still be theirs. So, we will definitely get to see the legal and banking implications of all this in a while. So, let's come to the banker's note section of this thing, shall we? Now, at the time of account opening, we obtain the HUF form, all details of Karta, and every other major co-partner of the family. ठीक है? And this has to come also in a form of a declaration from the Karta. And during a loan account opening, if Karta signs, he binds himself and the entire property, HUF property or business, including the rights of co-partners in the property. However, if you want to, like we discussed, the co-partners will only be liable to the extent of their right on the HUF property, but not on their personal belongings. But as a matter of giving loans to an HUF, the bankers generally make sure that all the co-partners individually sign the documentation of the loan so that they are also held individually liable. So, when there is change in an HUF constitution. एक HUF की constitution में change आता है when a new member joins the family or dies, or when a minor attains his age. So whenever all these things happen, you take the consent of the, let's say when a minor attains his age, you take his consent that he is now officially and formally a member of the HUF, and that he will be held liable or to the extent of his share on the HUF. And if a member dies, it is prudent for the bank to obtain the documentation once again so that the loan can be secured properly between all the remaining co-parceners. Now here's what a co-parcener cannot do. Until, like we said, कर्ता के पास authority होती है that he can delegate a co-parcener to handle the affairs of a family to a certain extent. So if he's been delegated a co-parcener, then only can he stop a payment or countermand a check. Otherwise, he cannot do any of those things. All such rights till then are vested with karta. That's it for now. Thank you.
So, you've got yourself a good education. Your foot is on the first step to a successful career. Great! On top of that, you've met your perfect other half and have set about planning your lives together. Bit of an issue though, he's not British and he lives in another country. But with your bright future ahead of you, surely this can't be a problem. Surely the immigration rules have a channel for a couple just like you, who are looking to start family life in the UK. Unfortunately, it's not quite so straightforward. Since July 2012, the UK has operated rules which mean you, as your partner's sponsor, have to have an income of at least £18,600 before they can come and join you. And if there's a child involved, the sum raises to £22,400, more for any additional kids. This is way more than the average income. 40% of people living and working in the UK earn less than this amount. Carol is one of them.
My name's Carol, and I used to be proud to be British. I met my husband Ahmed in uni, we fell in love, got married, and then decided to move back to Southampton to start a family near my parents. But getting the visa was a nightmare. Ahmed's from Iran, and I had to earn at least £18,600 for 6 months so that he could stay with me. I was shocked. He was forced to leave the UK when I was just 3 months pregnant. I did everything to find a job to bring him over. Luckily, I was offered a very good position in a law firm. However, I'm still not earning enough money for my husband to live with me. Ahmed is an accountant and could easily get a job in the UK. I mean, he's working in Iran right now. He's earning money, but the Home Office don't want to know. Even my mum and dad offered their money, but they threw it back in our faces. Makes me sick. Our beautiful daughter Fatima is now nearly 1, and she still hasn't met her father. If that's not cruelty, I don't know what is.
Why has the government adopted this policy? Is it because they think that unless you're earning this sort of salary, you're not going to integrate well into life in the UK? What will this mean for you if you can't bring your partner to join you? The UK government is expecting to refuse 18,000 people the opportunity to join their families each year as a result of these new immigration rules. They affect people like Carol, Ahmed, and their baby daughter Fatima, and many other British citizens. The Divided Families campaign is fighting to change these rules, to bring justice to migrants and British citizens whose human rights are being challenged. If you believe in fair immigration regulations for families, support us.